Good morning, good afternoon, and good evening to you, depending on where you're watching us from. I'm Azuka OJ, and please subscribe to our YouTube channel, follow us on Facebook, Twitter, and Instagram for more updates. The Supreme Court last Monday fixed May 6 for judgment in a legal tussle between Rivers and Imo State over the ownership of 17 oil wells in their territories. Justice Olukayode Ariwola, who led a 6-man panel of justices, fixed the date after taking arguments from lawyers involved in the suit. The plaintiff in the matter, Rivers State, represented by Mr. Joseph Daudu, SAN, asked the Apex Court to give judgment in favor of the state on the ground that the historical evidence rights from 1927 till date clearly indicated that the oil wells belong to the state, that's Rivers State. That drew the attention of the Apex Court to the boundary adjustment paper of 1976, where Ndoni and Ebema communities were confirmed to be in Rivers State. He disagreed with the Attorney General of the Federation, AGF, in his claim that adjudication of the suit on the oil wells ought not to have originated from the Supreme Court, but at the Federal High Court, because oral evidence ought to be taken from people in the disputed areas. Now they argued that the Supreme Court has original jurisdiction and can conveniently use all available sufficient historical documents right from the colonial era to determine the real owners of the oil wells. However, counsel to the Imo State government, Chief Olusola Oke, SAN, asked the Apex Court to dismiss the suit on the grounds that it ought to have originated from the Federal High Court. Claimed that because of the nature of the matter, oral evidence ought to be called from the people of the area to confirm where they actually belong. He contended that the Rivers State ought not to have started the suit from the Supreme Court and therefore prayed the court to dismiss the suit. In the same vein, counsel to AGF, Dr. Remi Olatubura, SAN, aligned himself with the position of the Imo State to the effect that proper procedure for such a suit was not adopted by Rivers State. He argued that the witnesses, including officials of the National Boundary Commission, Surveyor General of the Federation, and indigents of disputed area ought to be heard for the court to make appreciable and acceptable findings. Although Olatubora claimed that the AGF was neutral in the disputed oil well ownership, he said, however, that scientific evidences must be considered alongside with open court hearing for the Supreme Court to make good findings.